Good morning, everyone, and welcome to the New Possibilities Hour. Today is August 31st, 2023, and we are delighted to have Malcolm McNeil as our guest today. This is part of the Will Work for Food project founded by Natalie Armstrong-Motin in 2020. And every Thursday, Jean Lawler and I are delighted to host another webinar for mediators, arbitrators, lawyers, and everybody who negotiates. As you know, there's no charge for these great presentations. Rather, we ask you to contribute to a food bank if you like what you see. And our audiences have been so generous in contributing in honor of our great speakers. Jean, would you please do the honors and let us know just how much our generous audiences have contributed so far?
Sure, with pleasure, Jeff. And hello, everyone. The number as of today, the amounts of donations about which we have been told. So I am always sure there's a lot more, but what we know of is $437,122.48. So that's just amazing and fantastic. And that's millions of meals. So thanks so much, everyone. Keep it up.
Fabulous, fabulous. Well, we have a great guest today, Malcolm McNeil, to talk about what litigators really think about mediators. And Malcolm is supremely qualified to discuss this. He's a partner in the Los Angeles office of the international law firm of ArentFox Schiff, and he's president of the Beverly Hills Bar Association, where he's done a fabulous job of leading the association in a series of continuing education, networking, and charitable projects over the almost 12 months now when he has been president. Malcolm, we're delighted to have you. Please tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so, and then give us the inside information. The floor is yours.
Well, thank you, Jeff. And let me just start out by saying thank you for setting up this worthwhile, informational, hopefully entertaining, and also worthwhile series of programs. I've been watching, and I've been a listener and a watcher, and I've enjoyed every one of them. And Jean, thanks for your participation in it. It's great. I think I can't say enough for the LA Food Bank. I mean, I've actually spoken at events. I've actually worked with different restaurants that have participated, and it's quite an efficient organization. So to the extent that anybody wishes to make a contribution, I wholeheartedly endorse a contribution to the Los Angeles Food Bank. So that's that. Let's move on to the inside information, as Jeff called it. 2 minutes, and I don't want to talk a lot about it, but I think it's relevant to this, to our program, and that is that a little bit about my experience, because right now I'm a partner, as you said, in ArentFox Schiff, AFS as we call it. But I haven't always been with a large firm. When I came out of law school, I wanted to do international work, and I started my own law office a year out of law school, went to the airport, joined the Westchester Chamber of Commerce, and the next thing you know, I had in 2 years an international practice, and I was doing all kinds of things that I never even heard of in law school. So that was that litigation that's usually spawned from that, as well as some other interesting work. It caused me to be litigating early on, and that was really pre-mediation, really establishment of let's say mediation as a direct part of our litigation. And so in the early 90s, as the Superior Court started the mediation program, I joined the panels because we didn't have the right kind of training, I thought, for the folks that joined the panel. And that experience was helpful to me because I was in a smaller firm and I was up against larger firms, and I felt in some cases I was being bullied in the process. And so it gave me a different perspective, and I carried that perspective forward with me in the practice. And I then joined Carl Smith Ball, and eventually Fox Rothschild, and then ArentFox. And as my practice, as the firms grew, I ended up finding that I was doing internal programs to lawyers about how to approach mediation. How do you select a mediator? So the nuts and bolts that Jeff, that you know so well based on your vast experience. But the issue was that I found that everybody was focusing almost exclusively, or 80% of the pie of mediation, on the qualifications of the mediator in a given area of law. For example, we want labor and employment, or we want IP, or we want somebody who's done a lot of entertainment work. And I tried to change that focus and that emphasis a little bit into looking not so much at the qualifications of the mediators that were being bandied about, but to say, look a little bit at the qualities of the parties. Who's the underdog, who's got the money, who's paying, who's the plaintiff, who's the defendant, what are the sensibilities and sensitivities of the clients. Focus first on what type of mediator personality would we like. And I was getting a lot of resistance when I started. The resistance was, well, no, I really need somebody that knows IP, or I really need somebody who knows entertainment law. I need somebody who knows whatever the area of law is that they were dealing with and what kind of controversy they had. And I said, no, I think what you do is if you switch it, you're going to find that of course we want people that have some subject matter expertise. But as you may know, I'm an attorney settlement officer for the federal court, and I get all kinds of things referred to me on that panel that I don't even know. There's some I'll get a very weird lawsuit involving the Department of Justice suing somebody under Title 13, and you're looking at it for the first time. There's not really any subject matter expertise person out there, perhaps who's mediating. But you learn through the excellent work of the lawyers in front of you, the area of the law, and if you have the appropriate instincts and the appropriate insights, those instincts and insights are going to go a long way to help settle the case before you turn to the discussion of whether or not that mediator has the subject matter expertise. Again, I'm not saying don't look for somebody that has that experience, but also look for somebody who you think is going to be the right fit for the parties based on where they are in the litigation at that time. So that's it in a nutshell. Everybody can go home. No, I didn't want to keep going, Jeff. I wanted to give you an opportunity to ask a question because you were so inquisitive with your guests. So I wanted to give you the opportunity to chat.
Well, thank you. Thank you, Malcolm. Those are great insights indeed. Let's dig deeper into the subject of picking mediators. And it's a great mystery to many mediators. You know, we go around to the networking events and we're often told, oh, Jeff, oh, Gene, we wanted to hire you as a mediator, but the other side, the other guy insisted on mediator X or mediator Y or Z. So you see a lot of mediators going around looking at name tags at networking events. Are you the other guy? Are you the other guy? I'm looking to meet the other guy. And so it's this great black box about how the negotiations typically go. And some people say, well, you never suggest your true first choice first because the other side always dings your first choice, thinking that they're unduly partisan or have some allegiance to you. And there's all sorts of old wives' tales out there, shall we say. How does it really work?
It's an excellent question because I've said to people, I've been at events and we're talking about lawyers are very smart people. I mean, we've gotten through college, we've gotten through law school, we've hit the books, we've been disciplined, we've passed the bar, and never have I met such an educated group of folks who are so at the same time suspicious, cautious, in some cases paranoid, in some cases mystically concerned about what the other side is doing, because every move that the other side is doing must be a move to my disadvantage. And unfortunately, that thinking does permeate the selection of a mediator. And I try and dispel that right off the bat. If I don't know a mediator, haven't worked with that person and he or she is referred to me, I immediately go and check them out and see what they've been doing. Are they with JAMS, ADR, independent? What have they been doing? How long have they been doing it? Are they a retired judge? What was their practice like? I try and get some background on the mediator themselves. You're right, Jeff. They're always worried that if somebody comes to me and says, by the way, if I hadn't met you before, Jeff, for example, and by the way, I did refer you as a mediator on a case recently, and I hope it works out. And I said, hey, I've been working with Jeff, and believe it or not, they hadn't heard of you. And so I said, well, Jeff's been around and blah, blah, blah. And so they recommended to the other side. And the good news in this example was they knew who you were. And I think there may be some synergies or agreements. But the resistance that we got was that we made the representation or the recommendation first. And when we make that recommendation first, there's a notion that that person is somehow biased, somehow they're going to lean into the referring attorney, et cetera. And my tip for everybody is that if you do want to be the first one to put the name of a mediator on the table, I've been very, very, let's say, successful in dispelling a lot of those cautious and paranoid notions by saying, hey, you know, I just wanted to let you know, I think for this dispute, somebody who'd be good would be Jeff. What Jeff did is he's actually mediated a number of disputes for me. He's got a pretty solid background. He's very, very very patient with the parties. In some case, he can press them when they need to press them. In others, I give reasons for why that recommendation is made that takes it out of the personal realm of saying, oh boy, I worked with Jeff on several occasions and he settled all of my cases. That's not, I think, the appropriate approach. I think the better approach is to talk about the mediator skills and why you think they're appropriate to a given transaction. So because I know that the general opinion is that is what I said. The first is caution when somebody suggests somebody. So give reasons as to why this particular. There's lots of mediators out there, as everybody knows. It's a crowded field, lots of places to go, lots of opportunities, and I don't think we should be wasting a tremendous amount of time and money and clients' money fighting and haggling over who the mediator should be. We should just immediately give the reasons why these 3 mediators, if that's the method that we select to select a mediator, that we tell them why we think these are the right ones for this dispute.
Malcolm, in that description, you mentioned briefly at the beginning some things that relate, I would say, more to status than skill. So how much of that persuasion has to do with status points, such as the mediator was a judge of this or that court, the mediator is associated with this or that provider or company, the mediator wrote a treatise on this particular area of the law, whatever it happens to be. How much emphasis do you put on those status points? And how much emphasis do you put on what you were describing as the skills of the mediator?
That's an excellent question, and we have to approach it case by case, client by client. As you know, I do a lot of international work. September 8th, I'm starting a trial in Santa Rosa. I'm representing a Dutch company that's in litigation in the United States. I am reporting to Dutch counsel that referred the case to me, who knows me. And though when we meet, we were unsuccessful in our mediation in San Francisco on that case. But in the selection process, my client was looking for somebody who had stature. From the overseas client perspective, they wanted a retired judge. They wanted somebody who they had confidence in, somebody who that was a let's say solid in the community in San Francisco. And we selected somebody who was a former complex litigation judge in the San Francisco court after much discussion with other attorneys in our San Francisco office. But the client was insisting on a retired judge. It wasn't, my personal selection would have been a bit different. My personal selection would have been somebody, a mediator, whether they're a lawyer or a retired judge, but somebody with a really good background in business. This was a contract dispute over whether or not a production line worked, et cetera. And I would have liked a mediator who was able to delve into the transaction, delve into the cost of the litigation, delve into the expediency of the mediation process and how that's better than a trial. And it would have taken and would have brought different skills to the table. But I will tell you that I do a lot of work out of Asia too, as you know, and the clients who are inbound from Asia, especially my Chinese clients, want somebody who is who's been a judge or somebody who's had a judicial experience, because there's a there's a let's just put the stature issue is larger because they're looking for somebody who's beyond me as the lawyer just making the representations. When I say that so and so was a former lawyer and they're a good mediator and I worked with them, I have to explain why. The benefit is that I've worked with them in the past and I think that I can get the case settled with them because they understand me and trust me. And that's a different issue than dealing with somebody who's been a retired judge, who they think has let's put it this way, they respect the system better in some cases when it's a retired judge versus a private mediator who's come out of private practice. And that's not my opinion. I'm giving you the general opinion from an overseas client coming in.
And then in cases such as the one you have with the Dutch client that you referenced, where you mediated with a high status mediator, you did not settle the case. Do you ever have luck? I know you don't smirk and go, I told you so, but do you ever have luck in a more subtle way of saying, okay, we tried that. Now how about going with my choice?
Yes. Well, the answer is yes. And as a matter of fact, I do. With my inimicable style, Jeff, I will throw an "I told you so" in there to the client, because I think that part of what they're asking me for is my capabilities and experience and advice. As Lincoln said, that's what we sell, is our time and advice. So if I advise you on what I think are the proper skills for a transaction, I'd like the client to seriously consider them. And the answer is yes. That's what I said. I said I would have liked to have had a mediator here who focused less on what was going to happen in the courtroom and what would have happened in his courtroom, and focused more on, well, here's how you reach a business resolution on it. So the style would have been different, and that's what I explained to the client. The bad news in this case, though, is that we're not really getting along as well as we would like with opposing counsel. So that's why we're going to trial on September 8th.
So the question, though, is, do you ever have a second mediation with a different mediator?
Yes. That's a touchy subject all the time with clients, because if a mediation fails, I mean, as I said, in the early days of mediation, before you were born, Jeff, and I was a brand new litigator, it was a very interesting time, because there were mediators out there who claimed to be mediators who were really not. And if the parties were far apart, the mediation lasted 8 minutes and they said, get out of my office and don't let the door hit you. I can't settle this thing. And unfortunately, that gave, in the very early days, bad, let's say, bad mediation karma, if you will. Now, when a mediation fails, typically the clients, if the mediator has read the papers and the lawyers have been prepared and they really had let's say, a vigorous opportunity to negotiate, and they think that progress has been made, I'll recommend a second mediation at that time. I always recommend don't rule out mediation, because one of the other things that I tell a client is that, and I've had disagreement among colleagues on this, but it's worked for me. And that is to say that even a mediation that fails in getting the case settled is not a failure of a mediation. Typically, we learn things from the other side. We learn what the lawyer's emphasis is on the case, what they think is really their smoking gun. We get some tips on how we're going to approach the case in the future. And we also see where there's an opening to recommend a second mediation. And I always end a mediation that has been unsuccessful in settlement to say, look, it's not over. We can always go back to mediation. You can go back to mediation as many times as you want if you're making progress. And I try and instill that idea in the client to begin with, so that they don't feel that, oh, we spent all this money, we hired the mediator and we had to pay you and blah, 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 and all of those things. And gosh, we didn't get any. The typical answer is we didn't get anywhere. That's the client's sort of stock answer for when the case doesn't settle. We didn't get anywhere. So I do spend a lot of post-mediation time in the ones that are unsuccessful, saying, oh, no, don't say that. You got some pretty good value. Here's why. We learned A, B, C, D, and E. We also know that you have an opportunity. The case is set for trial in 8 months. We can have another one in the meantime. Let me do a couple of more, let's say, discovery issues. We're going to do that. We're going to take the subpoena and we'll do the subpoena of ABC company. Let's do that and then approach mediation again and see if we can settle it. But you've learned that. So I try and make sure the client, even in the unsuccessful mediation, sees the value.
So, Malcolm, let's dig more into the distinction between the mediator status and the mediator's skill. It is sometimes difficult, challenging for mediators to describe cogently exactly what are the skills for which lawyers should be looking. Because let's face it, a lot of time in the mediation, we are rather quiet, and the lawyers and perhaps your clients are rather vocal. So I'm curious to know from your perspective, how do you describe a mediator's most important skills? And even more importantly, how do you measure them?
That was, let me deal with the second one, how to measure, and then I'll get back to the skills. The measuring typically takes place by checking around, calling people, calling other lawyers. We internally, we have I'm the co-leader of our West Coast, which is LA and San Francisco. I can send out a blast. Have you ever met with Jeff Kachavan? Has anybody had any experience with him? And then I usually get 2 or 3 inquiries back saying, or responses back to my inquiry saying, yeah, I worked with him. He settled this case for me. I had a personal injury case over here and we defended this trucking company, or there's an employment case over there. So I'll get a sense for him. And then I'll ask them, I mean, what are his personal skills and demeanor? Because I have some clients that are tough as nails, business entrepreneurs, and that is a certain type of mediator that I'm looking for, who can take the bull by the horns and not be too, let's say, soft on the client. And I'll tell the mediator ahead of time in a pre-mediation discussion, my client's a little bit tough as nails here, so don't be afraid to get in his face a little bit, because he may get in your face, but he's a lovable curmudgeon. So to be happy to talk to him, etc., that kind of thing. And so I'll try and give some tips to the mediator on how to approach it. And then there are other cases where you have older clients. You may have clients in their late 60s, early 70s. They got embroiled in litigation somewhere. They want it over with, and we need somebody who's going to approach it with more of a, more of a counseling type of strategy, unless of course it's a very serious family dispute. Then I need somebody who's willing to pull out the family card and talk about why family harmony is so important, and I need a mediator who's going to feel comfortable in that environment. So those are the things that I'll be looking for on a personal skills level and a personal, let's say, sensibilities level for the mediator. So then you go back and say, okay, now am I able to find somebody who about 4 months ago, I actually was a lawyer in a very hotly contested probate case. And I'm not an expert in probate, but I do know what was going on in this particular dispute, family dispute, as you might imagine, much like probate is family law, I call it, because everybody's fighting and everybody's vying for money. And it's just it's an unfortunate situation, and relationships are breaking down. And so in that case, I wanted a mediator that sort of understood the probate court, knew their way around the probate. They didn't have to be an expert, because I'm not an expert in probate, but I was an expert in litigating this. Not an expert, but I was well versed in litigating this particular dispute, and probate court is crowded. So I wanted somebody who was able to talk with high qualifications about navigating through probate court, while at the same time dealing with those issues, those let's say the what I'll call counseling issues of how do we repair the family relationship and at the same time settle this case. So I was looking for a mediator that could navigate those two realms, if you will.
So what you're describing, Malcolm, might be characterized as quote unquote soft skills. And at the same time, you mentioned that when you ask your colleagues for feedback about mediators, first thing you mentioned, and the first thing many people mentioned, is, oh yes, mediator X, the case settled or the case didn't settle. So how do you get beyond a binary result, the case settled or didn't settle? And we all know that sometimes it is the mediator's fault or responsibility, And sometimes it's not, right? Because sometimes somebody is just really stingy or really greedy or really emotionally intense about a case. How do you get beyond the raw, it settled, oh yeah, he's good, it settled, or oh yeah, he's bad, it didn't settle, and get into some of these so-called soft skills that in your judgment make so much difference?
I fall back a little bit on what I said earlier, and that is that talk about what you got out of the mediation. Because I don't think you're quite right. Look, I have colleagues of my own right now who if it settles or doesn't settle is the singular measure of success. And I don't think that settling or not settling is the singular measure of success. Obviously, we're going to mediation to settle, and some of my colleagues, and when I say my colleagues, I'm not referring to internal colleagues, but I mean, look, as you know, I'm president of the bar, and I've met people in a whole variety of contexts. But the measurement is by we tend to measure things by winning or losing. And settling a case is winning, even if our client doesn't get everything we want, but we've had a successful result, we think. And so we have to change that kind of think. And what we have to say is, okay, now as a result of this, it's not a binary choice. It's that what did the mediator do right or wrong, or what is it that we would, and not so much wrong, but what is it that we wish they had emphasized differently during the mediation? What is it that we know that we've learned from this when we make another selection, or if we go to bat again in a mediation context for our client? So I try and take it out of that, because I try and make clients see the value they get out of anything that occurs in litigation and mediation, because litigation, as we all know, is for a lot of people has been described as a zero sum or a minus zero game, because you're already upset that you're in litigation and you've either been paid for your job or not paid for your job, and now you're litigating and losing what you got paid, or you're going to have to pay more or whatever. So clients are already aggravated with the process. So as we're taking a deposition, for example, I'll say, no, I really want to get the deposition of Bob, because Bob, he's pretty pivotal. He was at the door. No, I don't think he's important at all, McNeil. I think that, why are we going to waste the money? And I'm like, well, we're going to spend the money because. And so mediation is part of that process. Mediation is not part of the discovery process directly, but it is part of the process in learning and understanding the case. So I think that at every step of the litigation case, because as we all know, there are lots of old wives' tales out there, some true, some not, about the issue of litigation in the States, and it's expensive, and the lawyers are billing, and they're trying to keep the case going, and they're delaying cases, and they're delaying it because they want to bill more. And you have all those things going on, and dynamics, but each client looks at those things differently. It's important to explore what your client's attitude is. Some clients will approach it and from a more business-like standpoint and say, yeah, sort of like that old joke, you're nobody until somebody sues you. So now I've been sued. Okay, fine, I got to deal with this lawsuit, and that's what I'm going to be doing. Other clients are like, oh my God, it's the end of the world. I'm in a lawsuit. I saw my name on the other side of a V. I don't know what I'm going to do. I'm so embarrassed. All my friends know about it. I'm mortified. Obviously the bigger the client is, if it's a corporate client, a Fortune 500 client, they care less about that. Those kinds of issues, unless it's something that's maybe embarrassing from a public relations standpoint, but otherwise it's routine litigation. Private clients, who have been my primary clients, I explore those issues more specifically with, because even business clients that I represent, I'm representing the owner of that company, and the owner of that company is typically somebody who doesn't want to be distracted by the litigation, everything's a waste of time, everything's a waste of money. And so in order to keep that client under control, it's very, very important at every step of the way to make sure that the client understands why something is occurring. And I mean, it sounds basic, but we get so wound up in our practices. Me too, by the way. I'm swamped right now working with my colleagues in San Francisco who are helping me on the case that's going to be in Santa Rosa. But at the same time, I have 150 other things that are requiring attention. And so that the balance of keeping clients informed, even of routine matters, it's easy for us to say, well, that's routine. I don't need to discuss it with the client. Well, discuss it with the client, and that includes mediation choices. Let the client know, let them know that we're in the process of selecting mediators, and we're in the process of determining which one's going to be the most effective. And you get the questions that you're asking at the outset, Jeff, were very important because clients are thinking those things, even if they don't say them. If I say, hey, I got a good mediator here, Jeff Kachav, and we both agree that he's the best guy for the job, the client is actually thinking at some level, well, if the other person, besides what Malcolm thinks, if the other guy thinks Jeff's okay, maybe he's going to be biased. That you need to be able to deal with that and to be able to respond and say we made a professional decision as to why we made that selection, not a personal decision because we think they're going to lean into our case.
Malcolm, do you ever take the extraordinary step of trying to call a mediator on the phone if you're not familiar with them, get a bead on their personality, see whether they might have the flexibility of personality necessary to deal with people on both sides of the case?
Yes, and I think, and there's a part of that too. Yes, I called, and there's been situations where that mediator hasn't called me back for about a week and a half. And guess what happens? I elect not to select that mediator. So for any mediators that may be listening, if I call you and I'm trying to get a hold of you to find out if we want to make a selection, be prompt in your responses, because I feel that's part of the process. Remember, mediators are there to help, right? You're there to help to settle the case. So if I'm calling you, typically you may not know right off the bat how soon I need you, or when you're going to be, or when the mediation is going to be. But I found by and large, they have been responsive when I made that initial call. And I say, look, I've got this business dispute. It's a production line. The attorneys are getting along, but the clients are not. Or alternatively, in our case, the clients aren't getting along and the attorneys are not getting along. That's the kind of case that we're going to be facing. What do you think about that? How would you approach that, just to get some idea of it?
And Malcolm, when you say that you hire a mediator to get the case settled, let's dig deeper into that, because that's not any more of an answer than when you call a colleague and they say, oh yes, mediator X got the case settled or didn't. Similarly, if someone asks you if you're a good trial lawyer, the answer has to go beyond, well, yes, I won the case or I didn't. There are certain skills that go into and comprise being good or bad at anything. So what exactly is it that you're expecting mediators to do to help get the case settled, or at least get the case to a point where you can leave the mediation room and say, yeah, I got my money's worth. This was time well spent?
I try to be brief in my brief. I always provide a mediator's brief. And in that brief, I know that it doesn't do you very much good for me to attach 13 exhibits, including the discovery responses from a year and a half ago, unless it might be pivotal to an issue in the case. As I said, as an attorney settlement officer, I've had those kinds of things given to me. So I get a stack of paper like this, and I'm looking at it, and I'm like, really? So I'm reading the brief to really get to the issues that I'm going to be able to discuss during the mediation. What I expect from a mediator is that the mediator has read the papers and is familiar with it and doesn't ask questions that make the client think that the mediator is disinterested in the process. I've had those kinds of situations. And who's the judge that this is on? And I read somewhere that there's a trial date. When's the trial on this, counsel? Nothing worse than that kind of a mediation style in front of a client. And the mediator should be crisp on all these things. Counsel, it's great. I see that you're going to trial on September 8th, so we've got just a few days to settle this thing. I see the dispute. It's a production line dispute, and I see they say X and you say Y. So how's that going to look at trial? You know, there's a mediator who appears invested in it rather than it's going through the motions. And unfortunately, that example that I've given you does come out because clients see it. Clients see it because what happens is if that occurs and then the client goes into the other room to have a discussion and then comes back into your room and says, well, you know what they said? They said your production line was no good. They said they couldn't make their cookies. They couldn't do whatever. Then the client's getting the impression that, well, they're not really invested in our case. They seem to be coming in and telling us all the negatives from the other room, but they really didn't understand the case from our perspective. So I think it's important that mediators, when they do present what we know occurs at mediation, which is in some cases to accentuate the negatives so that a client has an opportunity to understand that those negatives are something that they may face in the litigation. That negative should be presented in a way that the client realizes is a balanced approach. Now, I discussed that with clients ahead of time. I explained that in a mediation, it's not up to the mediator to buy into your case and immediately accept your position and tell you you're going to win. Because if the mediator does that, then they're not doing their job. That's not their job. Their job is to point out what you should be thinking about and what the challenges of your case are. But the mediator must look like they're invested. The bottom line to what I just said is the mediator must show the client that they're invested in the case and they've got the basics under control before they start talking about it, and not ask questions that suggest that the mediator has not quite gotten up to speed.
And Malcolm, what you're discussing implicates the question of neutrality, that the mediator not appear to be arguing with you or not appear to the client to be taking the other side. And in some sense, Malcolm, isn't the answer to that, the way out of that box, to go back to having some kind of joint session or some kind of direct communication so that, let's say, we look at the briefs, mediator has a phone call with you, and we determine that the issue is X. Were the cookies compliant within the meaning of the Uniform Commercial Code? Do they reasonably comply with the specifications for such cookies? Mm-hmm. And if we can have some kind of a joint session where lawyer X says, well, we don't think the cookies were compliant because we measured the number of chocolate chips and the diameter or whatever it happens to be, and we hear lawyer X say that in a joint session, then when a mediator goes into a caucus with you and says, well, you know, Malcolm, they said they measured the number of chocolate chips and the diameter and that it wasn't up to the specifications. How about that? My sense is that when it's that kind of a conversation, we're much more likely to have some persuasive impact on the client rather than if the mediator just comes in cold, parroting or cribbing what's in the other side's brief, because then it does look much more, I think, like the unproductive kind of argument you were just criticizing. What do you think of that?
I couldn't agree more, Jeff. And for the benefit of everyone here, Jeff and I haven't had this discussion before, but I fully agree with that. I've seen the trend in mediation in the beginning of, let's say, the emergence of mediation as a routine part of litigation. We used to always have those. I always had the meetings to begin with. By the way, an opening meeting now where everybody gets together and says, and I've seen the trend now where mediators don't do that anymore. I do it, by the way. I want to get everybody together, so I give my typical comments about confidentiality and what they can expect from the mediation process. I do it with everybody together. And counsel are hesitant. And look, I'm a lawyer 98% of the time. So I'm the one that would be happy to do that with my clients. But there seems to be a belief and a hesitancy for that at the outset. Now you're talking about something that occurs later on within the mediation context where the mediator actually meets with both counsel. I wanted to meet with counsel, by the way, in the case that I just told you about. And the judge says, I don't find that, retired judge, I don't find that very productive, Mr. McNeil, because what happens is it just digresses into an argument, and that's why you're here. This is litigation. You both have different opinions, so a joint meeting doesn't work. I'd rather continue just going back and forth. And I thought that was the wrong style for this particular case, especially since I had 3 clients that flew in from Holland for this deposition. It would have been a great way to demonstrate the value of the process. And it's also a good way for the mediator to look for, let's say, a nugget from that conversation that allows for a private discussion to seize upon it and say, you know, I heard this, and you might want to talk to your client about that, and it would give an additional tool to the mediator. So I'm a firm believer in joint participation in the mediations, because I think it gives everybody an opportunity to know what it's a tiny sense of what it's going to be like in the courtroom when your views are challenged.
So to make clear, Malcolm, I am talking about joint sessions with limited tailored agendas that include both lawyers and clients, perhaps at the very beginning or close to the beginning of the mediation day, as well as conversations between counsel. You know, mediation is supposed to be a flexible process. So if they are as productive as you think they are, or I think they can be in particular cases, why do you think we've gotten away from it so much? I have a theory. I'm interested in yours.
I have a theory which I think is tested and correct, but just from asking people, and people say, why, when they start to shy away from it, I said, well, why? What's the, oh, well, you know, my client doesn't like them. They got into a fight. They got into a dispute. They're just going to look at each other and they're going to glare and they might yell, or there might be a conflict. And I'm like, well, this is litigation. Okay, so there may be a conflict. I think the conflict has already occurred, frankly. So, but if we get them into a room together, that gives them a sense where they're going to be sitting in a courtroom 2 or 3 feet apart from each other if they go to trial for 9 days. So let's look at it that way. But that's what it is. And there's also a fear that the mediator is going to ask something. What I've experienced is there's a fear that if I were, as I said, if I was doing one of these for the federal court, that I say, well, by the way, Jeff, you know, I was noticing here that you took the deposition of Jane, and that deposition took place back in June. What did she say about the fact of whether or not this production line was working? And you don't particularly remember at that particular moment as counsel, so you're worried about maybe looking potentially embarrassed in front of the client by not being able to respond to a query about the case. That's the first reason. The second one is that I think that because one of the benefits I said of mediation at the outset is you learn things from the other side. Everybody's afraid of tipping their hand during that discussion. So when I asked that question, what did Jane say about the production line? Somebody's worried about, by their answer, that they're tipping off the other side to either a nugget that they think is going to be important in the litigation, or that somehow they're going to miss something. So I think it's an issue of being put on the spot by and large, which is what takes people away from that. So I've tried to have the discussion ahead of time, say, look, I'm not going to do anything in an open session to embarrass anybody. I just want to see the dynamics of the parties when they're in the room together and when everybody's talking. So counsel, relax. It's not going to be an issue. It's not going to be a problem.
So that kind of preparation, I agree with you, can defang some of the hostility or reluctance to engage in a joint session by narrowing down the agenda and making clear that it's not a star chamber proceeding for anybody. My theory, Malcolm, is that a lot of mediators simply lack the confidence and lack the skill to run a joint session, and lack the confidence and skill to keep emotional outbursts from happening and to control those emotional outbursts if they do happen. So circling back to something we were discussing a few minutes ago, when you screen for mediators, part of your due diligence, do you ask about the skill and the ability to run a joint session?
Yes, every time. And well, I'll give you a good example too. I mean, we just came out of the I don't refer to the pandemic as the pandemic. I refer to it as the plague. Okay. So we just came out of the plague era. Okay. And in this era, everybody got a little too comfortable with Zoom. And we all, this is not the place to talk about the pluses and minuses of Zooms and when you can use them and what kind of hearing should be on Zoom and blah, blah, blah. But we all know that it's a good form to save time and money for some types of hearings. But I do find that Zoom accentuates if a mediator tells me that they're only doing mediation on Zoom these days, that's convenient for me, but it's really not conducive to the process. I think I would imagine anybody here who's been in a mediation, and hopefully most of our viewers and listeners have been in mediation sessions, that face-to-face, being responsible for your decisions, yes, no, negotiations, what's going on, being in the same room is critical. In my opinion, being able to shuttle back and forth is critical. And I just think that mediations are going to be much less effective if you cannot go and have a face-to-face mediation. That's a step away from exactly what you're saying. So I've had this discussion, and we've rejected mediators recently. Said, I only do mediation on Zoom. And I said, I had 2 words for that. Oh, well, thank you. Okay. And then I've gone on and I've looked for somebody who's prepared to do a mediation face-to-face, because that's an adjunct to the comment that you made, Jeff. The comment is, do you have that discussion ahead of time that you're willing to have a joint session? Yes. But at the same time, I want that feel. I hear a lot of arguments about whether or not when you go to trial, what can you see on a Zoom? And I have an arbitration coming up where the arbitrator, it's an international arbitration, so much of it's going to be on Zoom. Great. It's going to be that convenience is let's say balances against having a face-to-face arbitration, but it still doesn't mean that a face-to-face arbitration is not going to be successful or not going to be preferable, I should say. But everybody wants to save time and money, so that's why they're doing it. In a mediation session or a mediation environment, I want mediation to be face-to-face. And I asked the mediator, Jeff, here's the scoop. These 2 brothers got into a fight over the business. They're stealing each other's employees. They're stealing each other's business. The families are upset. Everything's going wrong. This is a real case, by the way. Everything's going wrong. They got into a fist fight. They both got arrested for assault and battery. They both have their own company. But I want us to have a joint session. And I want us to have a joint session because there's a few tools that we have, and you can collaborate with a mediator in a very ethical way to say, look, let's get these guys in the same room together. Let's get them talking, because let them see that if they go to court, as I said a moment ago, when they go to court, they're going to be sitting in the same room. So why shouldn't they be sitting in the same room for a mediation that's going to hopefully save them time and money? And if the mediator is reluctant, then I know that maybe I need somebody with different sensibilities.
To sum that up, Malcolm, I think that my view is that if a mediator says, well, I just don't do joint sessions, it would be analogous to a litigator who said, well, I just don't do summary judgment motions because they rarely win. Well, would a client ever hire a litigator who just categorically said there's a tool which is sometimes useful and appropriate, but I just don't do it? I don't think that litigator would get very far in the marketplace. And similarly, my personal view is that mediators who don't have the skill to run a joint session in appropriate circumstances don't deserve to go far in the marketplace either. Before I call on Suzanne Winlove-Smith, we have one question in the chat which came in a little sooner than Suzanne raised her hand. Question is, please ask our speakers, from Neil Dilloff, please ask our speaker how far he goes in asking the mediator for his or her prognostication about what may happen at trial, considering the principle of self-determination and the prohibition against the mediator providing legal advice to the parties.
Excellent question. I think that if you ask the mediator for their opinion in that process, then I think that the mediator is not violating any neutrality issues, because I think the mediator can say, you can ask the mediator. It's a dangerous question, by the way. I want to say that to start with. It's dangerous because the mediator is only working with what the mediator has in front of them. And I'll also tell you something else. I've dealt with that issue on the USDC pro se. I've had pro ses come to me and say, well, do you think I'm going to win? You know, things like that. So you have I've not had a lawyer ask me that particular question, not in that way, or not that directly, but I've had people come up to me and say, do you think I'm going to win? I should win, you know, because they did these awful things to me and I should win. And I'm like, well, you understand that even if I was certain you were going to win, the answer would be you have an 80% chance of winning. And the reason for that is because our system is the kind of system that you have to see what happens at the time of trial. You're going to have to see what happens. There are surprises. There are things that occur. So that's the bottom line. You cannot ever say with certainty that you're going to win or lose, even if you have the best case in the world. So to answer the question directly, I think that I've asked mediators, not whether we're going to win or lose, but I have asked them for an independent judgment on a given piece of evidence, such as you read the deposition transcript of Jane when she gave that, and you read what we consider to be the 11 lines of something that's pretty critical, that's going to be devastating at trial. Do you agree? And then I've asked those kinds of questions, but I've never asked them to prognosticate on the ultimate outcome, because I think it's an unfair question for the mediator. It's unfair because the mediator doesn't have the benefit of having sat through exhaustive discovery if it's occurred. And if the case is too soon, we just mediated a case that was filed in federal court on trade secrets. And it's an expensive case. There's a preliminary injunction hearing pending. And so we both sides agreed. We're on good terms with counsel, and we both agreed that we're going to go into mediation right off the bat. And we did. We selected a mediator, retired judge at ADR. After fighting a long time, by the way, on who the mediator is going to be, believe it or not. But anyway, we did that. And so at that point, it would have been unfair to ask the judge what the judge thinks was going to happen at the preliminary injunction hearing, et cetera. So I think that asking is not necessarily the thing to do, just because unless you're trying to get rid of the client, I guess, and say, well, even the mediator thinks you're going to lose, then it maybe as a client control tool, but other than that, I would say I would stay away from it.
Fair enough. Suzanne Winlove-Smith, if you would please unmute yourself and ask Malcolm McNeil your question.
Thank you. And, it's just shocking to me. I'm sorry that I came on late. I'm actually working the courts as the on-site mediator with very high conflict clients. And I've worked with hundreds of high conflict clients, and actually with great success. And to me, it seems absurd and shocking that a mediator would ever say, I don't hold joint sessions. It goes completely against what is at the core of making mediation successful, because typically clients do want the same thing, right? They want.
Absolutely.
And they're not that far off. So how do you do that without having them in the same room? I always discourage my clients from doing shuttle mediation, even when they're really afraid, or the lawyers, because what's the alternative? The alternative, they're going to continue to suffer. So,
well, yeah, Suzanne, you're preaching to the converted here, because I've said the same thing, and it's almost become part of the fabric of mediation in some ways. And by the way, I'll give you the reverse side. I went, WIPO did a mediation seminar that they invited me to in Geneva 20 years ago. And it was a 3-day session, and they had one of the speakers has written a very important book on mediation. And for him, every session is joint. He won't hold any private sessions. So then when I was listening to that, he said, because I believe that if you go into the other room, you tip the scales, because people get the wrong impressions. And so he went the other way, that if you want to talk about it, we're all going to talk about it together. You have something private to tell me right here in front of everybody. And he says that way you maintain the integrity of the process, and clients buy into the mediation. So I didn't agree with that one. because of course we all know that, I think many of us, with the exception of this high profile negotiating mediator, understand that there are things that people want to talk about privately, so that I get a better frame of reference for advising my client. But Suzanne, I fully agree with you, and I insist. They say, well, I don't want to do it. I'm like, well, I may be the wrong person, so go back to the panel and get somebody else. I don't do mediations as a practice. I have done them for clients, international clients that they've known who I am, etc. But I'm a lawyer, so but the mediations that I've had, I've always said, let's do a joint session. And I've asked as a lawyer, I've said, I want joint sessions. And so I'm happy.
I think there's a lot of misconceptions really about what mediation is. And to me, that's kind of disturbing, because really to think that we're there to make any kind of decisions. I see what my job is to create safety and security so that whatever needs to come out can come out. And I'll tell my clients, this is the place to have those tough conversations, the things that really, really scare you, because I'm here to support you and we'll get through this. And it's when people have the courage, right, to be vulnerable, but they aren't going to do that if I don't hold the space and create the safety for that to happen. And that's really when the magic happens, right? Where people make the breakthroughs. So I always say it takes like a strong person to be vulnerable. That's like just the quality of a strong person. So it's the little tricks you do, but having them together it's just interesting with hearing you talk, because I don't know if it's different in the States, right? I mean, I'm in Canada, and I think everyone has their own style. We all work so independently. And that's a problem too, because I think we have so much to learn from each other.
Fully agreed. Fully agree. I saw somebody pop up with another mention in chat that they went through they had the same experience I had. And I didn't quite see it. Oh, from Gil Mansfield. And yes, I'm glad you had that similar response, because I'm telling you, it's just there's one beautiful thing about mediation, and the beautiful thing about mediation is that we're all able to take the styles and personalities that we have and the skills that we have with clients into the mediation process. And we're all different sizes and shapes, and we all look different, and we all have different experiences, etc. But what does allow it to coalesce is the way the mediator handles the mediation. And it's up to the mediator to be able to see that you've got a hot shot in the other office who's yelling, and somebody else over here who's taking notes of everything that occurs. And you need to be able to take those those attributes of counsel, and to be able to put them together and find a way to get them to settle a case, or at least think of their case differently. Because I've also said that to clients too, is if you go into a mediation and you settle your case, great. If you learn things, great. If you look at your case differently, great. There's a lot of benefits to mediation beyond the ultimate settlement. And it's hard because clients are taught, it is binary, as Jeff was saying earlier. For some people, you either settle or you don't. Or I went to this mediator and didn't settle, so I don't like him or her. Well, that's not the non-settlement is not, there's so many factors involved in the concept of settling that you can't blame the mediator for it unless the mediator was inattentive. That's the only time I've blamed mediators, Jeff, is when they're inattentive or don't seem that they're engaged, or they're somehow, they're doing something else, or they're just, disinterested in the process.
Well, Malcolm, thank you for engaging with us at such a candid and deep level during this past hour. It's been a tremendous conversation. I know that a lot of people here are going to be contributing to the LA Regional Foodbank in your honor. That's www.lafoodbank.org, www.lafoodbank.org. On behalf of Natalie, Jean, and myself, Malcolm McNeil, thank you very much for a really excellent presentation. And with that, we are complete.